Good afternoon, everyone. My name is Dan Tokaji, and I am the Dean of the University of Wisconsin Law School. It is my privilege to welcome you to this year's Kastenmeier Symposium. We often call this the Kastenmeier Lecture, but this year we're doing it in a group format as a panel on the topic of patents and the public interest in pandemic vaccine policy. It's especially appropriate, I think, in the Zoom environment that we have this as a conversation rather than simply a single lecture. As many of us have found, a conversational style format tends to work better, I think, when we're doing these things via Zoom. And it also enables us to incorporate a variety of perspectives into this illustrious event, which is always one of the highlights of our academic year calendar at the University of Wisconsin Law School. We talk a lot at Wisconsin about law in action. It is our motto. And this panel in particular, I think, embodies the concept of law in action because it features not only fantastic scholars in the field, but practitioners, people who are actually very active in the real world in working on the set of issues that is the subject of this symposium, and of course is especially timely given that the pandemic is still with us and indeed has become endemic. So it is my privilege to begin by introducing the panelists and then turning it over to the moderator, who I'll introduce last. We have three panelists along with our moderator today. The first panelist is Andrei Iancu. He is a partner at Irell and Manella, focusing on intellectual property litigation and counseling. He previously served as Undersecretary of Commerce for Intellectual Property and Director of the U.S. Patent and Trademark Office, a position for which he was unanimously confirmed by the U.S. Senate. Among Andrei's initiatives as director was the creation of the National Council for Expanding American Innovation, a group of industry, academia, and government leaders tasked with helping develop a comprehensive national strategy to broaden participation in the innovation ecosystem demographically, geographically, and economically. Second panelist today is Dan DiNapoli, a partner at Arnold & Porter and a patent attorney for Pfizer. He concentrates his practice in patent, trade secret, and unfair competition litigation and counseling. His IP practice includes litigation, arbitration, and advice regarding patents and trade secrets in biotech, pharmaceuticals, and litigation involving many of Pfizer's blockbuster drugs. He's represented leading research-based pharmaceutical and biotech companies and does so in all aspects of complex patent litigation. Our third panelist is Lisa Larrimore Ouellette, Professor of Law, and Justin M. Roach, Jr., Faculty Scholar at Stanford Law School, as well as a Senior Fellow at the Stanford Institute for Economic Policy Research. Her scholarship addresses empirical and theoretical problems in IP and innovation law. She takes advantage of her background in physics to explore policy issues, such as how scientists use the technical information in patents and the integration of IP with other levers of innovation policy. Finally, our moderator today is our own B.J. Ard, an assistant professor of law here at the University of Wisconsin Law School. He teaches and writes on IP, privacy, and tech law. BJ was selected by the student body last year as our Classroom Teacher of the Year, and his work has been published in numerous distinguished law journals, including the Emory Law Journal, Yale Law Journal, and the Harvard Journal of Law and Technology. Before joining us at UW Law, BJ served as a research fellow at the Yale Information Society Project, where I understand he knew Lisa, and in private practice at Irell, where I understand he knew Andrei. So, BJ, with that, let me turn it over to you to moderate this wonderful panel that we have with us today.
Thank you, Dean Tokaji. Let me start by saying how thrilled I am to welcome each of you here the panelists as well as our audience. Each of our panelists has prepared a few remarks on the subject of today's symposium. And in a moment, we'll begin with those. Mr. Iancu will share his remarks on the role of the patent system and the advisability of the various IP waivers that have been proposed and that you may have seen in leading newspapers' headlines. We'll then hear from Mr. DiNapoli on practical obstacles, including but going beyond patent, to also consider issues like data protection and trade secret law and how they've manufactured the manufacture and distribution of vaccines. And Professor Ouellette will then put these proposals and these protection regimes in context with a wider range of policy and legal concerns that we need to confront moving forward. These remarks will be followed by discussion among the panelists and then questions from our audience. We welcome you to submit those questions anytime via the Zoom Q&A feature. You should find it at the bottom of your screen and send those in at any time so that they are there when we get to that portion, after which Dean Takagi will conclude the event. As we get started, I also have one housekeeping note for those who may be seeking CLE credit. So I just want to let you know that this year's lecture is currently pending CLE approval by the Wisconsin Board of Bar Examiners. If you would like to receive credit in the event that it is approved, please listen for the passcode, which I'll give out at the end of today's lecture, symposium this year. And at the conclusion of the event, also look out for a link to a Google form that will go out in chat. That's where you'll need to enter the passcode. So without any further ado, it's my pleasure to pass the virtual lectern to Mr. Iancu.
Well, thank you, BJ, for for the invitation and for the wonderful introduction. I remember fondly working together all those many years ago. Maybe it seems less than that now, but it's been good to follow your career since then. And thank you to the Dean for the invitation to be here with these wonderful co-panelists. Let me start by stating the obvious. The worldwide pandemic, the COVID pandemic, is an utter and tragedy with really virtually no silver lining. So many people dead around the world, so much pain and suffering at every level. Having said that, the medical response to it has been miraculous to a large extent. In less than a year from the beginning of the pandemic reaching the United States, we had not one, but multiple vaccines created, tested, and approved by the FDA. And not just any kind of a vaccine, but these vaccines showed high levels of safety and efficacy well beyond even the most optimistic expectations. That is fantastic news. And I firmly believe that none of that would have been possible without decades, at least, of innovation that continuously improved the technology available and the science behind it all to get us to where we in a position to be able to respond as quickly as industry did respond. Now, at the same time, there is indeed a level of inequity in the distribution of not just the vaccines, but all sorts of COVID-19 related technologies, as well as lots of other medical technologies. There's an inequity in that distribution around the world. While here in the United States and other wealthy nations, we have more than enough vaccines to vaccinate the entire population, including young children now, including we're thinking about booster shots now, and there's certainly supply for that. In many nations around the world, even the most vulnerable have not been vaccinated. The penetration rate in some countries around the world is as low as 1 or 2% when it comes to these vaccines. So the question is, what is causing that inequity in distribution of vaccine? And I'm sure throughout the symposium today, we'll talk about a lot of causes, but I will say what is not causing that inequity, and that is intellectual property protection. As a matter of fact, I firmly believe that intellectual property protection is at the core of our system that has allowed us to get to these vaccines as quickly as we did, and to create such effective technology as we did. And as a matter of fact, I also believe that IP didn't just help create this innovation. We wouldn't even be here to discuss these issues without that, in my view, without IP protection for a long period of time. But in addition to that, it has increased, not decreased, but increased the distribution of vaccines around the world and the collaboration between companies from around the world. For example, take just the Pfizer vaccine. Pfizer and BioNTech collaborated, obviously, to create that vaccine and distribute that vaccine. So that's an international collaboration between a large company and a small one. Large companies are collaborating with each other, such as Johnson & Johnson and Merck. AstraZeneca has a very significant deal with the Serum Institute of India, under which India is manufacturing effectively 1 billion doses, second only to the United States. And there's hundreds of these collaboration agreements around the world, hundreds, at unprecedented levels. And I firmly believe that but for intellectual property protections and the respect for the rule of law, these collaborations would not have been as extensive as they have been. And because if companies do not trust that their IP will be respected, they will be less reluctant, not more reluctant, less reluctant to collaborate and disclose their highest secrets to potential competitors and others around the world. But there are issues. There are issues that contribute to the inequity of distribution, including export controls, logistics of distribution, such as refrigerated trucks and many other things, finances, the availability of the ability of countries to purchase the vaccines, and so much more. I don't want to spend too much time at this point because I think others will get into that. Now, of course, as BJ referenced, there is an international push now, despite all this evidence of the importance of intellectual property to get us to where we are now. There is an international push to waive intellectual property rights across the board. There is a proposal at the WTO, the World Trade Organization, initially put forward by India and South Africa, but now quite a few other countries have joined that request, to waive all IP rights surrounding COVID-19 related technologies. And by all IP rights, it really is all IP rights. It's not just patents, but it is patents, of course, first and foremost. It is also copyrights, industrial designs, and trade secrets. All of those are proposed to be suspended. For how long? Well, effectively for an indefinite period of time. The WTO works by consensus. In other words, if any one member objects, then they cannot change the rules. So if this waiver is put into place under the proposal, which does not have a specific termination date in place, under the proposal that's on the table right now, effectively, you would need to come up with consensus yet again years down the line to try to undo the waiver of intellectual property rights. And it is very difficult to imagine that the circumstance will arise when all countries of the world will agree to undo the waiver down the line. So the proposal is very troublesome, and I want to leave folks with this. The proposal to suspend all IP rights, if implemented, it would be unprecedented in modern times. And before it is implemented, I believe governments around the world have a responsibility to the world to show the evidence, bring to bear the evidence before such an important decision is made. Number one, show the evidence that waiving IP rights is in fact necessary, that in fact IP has been acting as a barrier to innovation, as some of these countries are maintaining, and therefore show the evidence that lifting IP rights, suspending them, will in fact remove such barriers. Second, show the evidence that waiving IP rights will actually work, that it will actually get more vaccines into more people's arms at a quicker rate around the world. Show the evidence that if we just lift IP protections, in fact, we will have more collaboration between companies and not less, more manufacturing facilities of these technologies around the world and not less, that the quality will be just as good or higher and not lower. Show that it will work for its intended purposes. And third, governments, before making this critical decision, have a responsibility to show the evidence that going in this direction will not create further harm, that it in fact will not harm the public, because we would be moving into uncharted territory when it comes to innovation and the creation of new technologies for critically needed medical relief. Show the evidence that by waiving these IP rights won't harm that process, that it won't result in less innovation and less collaboration, as I've mentioned. So in my view, as you can tell, I don't believe that they can make this showing. And in fact, all the evidence is to the contrary. And that's why I think it would be a very bad idea to suspend intellectual property rights. But it's worthwhile to have the discussion, obviously, since it's being brought to the forefront. And we should not have the discussion, though, in a politically charged environment driven by emotion and political motivation, as opposed to hard-nosed economic and scientific evidence as to the needs, effects, and consequences.
Thank you, Andrei. Plenty that I'm sure that the panel would love to discuss further. But first, let's hear from the rest of their panel with their prepared remarks. Let me turn it over to you, Daniel.
About that, can you hear me? Yes. Good. Okay, I'm going to touch briefly on two issues that raise concerns surrounding access to patented drugs in addition to patents themselves. One is the way that pharmaceutical companies conduct research and development can lead to situations, and often does, where a patent on a drug itself might not include other technologies that are necessary in order to make the drug itself and therefore provide access. And that shows itself in particular with respect to trade secrets on manufacturing processes. The second relates to the legal framework related to the FDA process and pharmaceutical patents, and in particular, some of the data protection that branded companies get with respect to regulatory authority approval of their drugs. Okay, turning first to the way that pharmaceutical companies conduct their research. They typically would begin with identification of a lead compound. And that's very early stage research that they're doing, where the scientists are basically searching for a molecule that has some predetermined activity. And at that time, the research is focused for the most part on in vitro or test tube testing and limited amount of in vivo or animal model testing. And because of that, the scientists don't need that much in the way of the compound to test. So they're not concerned about issues surrounding the manufacturing process of the molecule itself at this point. So they have little concern for yield and little concern for impurities that might be harmful to humans. In addition, since the molecule at this time is not being administered to humans, there's less concern at this time for issues concerning the bioavailability of the molecule, as well as the stability over the long term for the molecule. Nonetheless, companies are motivated to file a patent on their molecule as early as possible, since to not do so leaves open the possibility that somebody else will do it before you, and then you're out of luck. While the law does require in a patent that one must teach how to make the compound, the disclosure that typically would go into this patent relates to this early research manufacturing process or chemical synthetic route, and not a route that is suitable for large-scale manufacturing as well as for administration to humans. Now, over time, of course, as the research continues, there's an increased need for both amounts and for the purity of the compound itself. And ultimately, once the company enters clinical testing, and usually around the time of the phase 3 study, they would have settled on a particular formulation, but they might not, even at that time, have finalized their manufacturing process for the commercialization of the product. Ultimately, once they file their NDA, or with respect to vaccines, most likely a BLA, at that time they would have pretty much finalized their commercialization or manufacturing process and included that in that submission. So we end up in a situation where the drug itself is patented with a synthetic route that may not be suited for either commercialization, and that you can't make enough of it by that process, or that it can be safely administered to humans. And instead, that information is developed during the development phase post-identification of the drug itself. Now, that's not the end of the story. Pharmaceutical companies and drug companies often collaborate with each other and grant access to trade secret information. And that information often can consist of documents surrounding things such as manufacturing processes, materials, and importantly, scientists with knowledge of the information. One important issue to consider is where this information is located, and in particular where the scientists are located. It may not be in a place that one wants to access the trade secret, so that's always a concern. And then, of course, it takes time to transfer the information. obviously documents and materials can be done reasonably quickly. But as far as working with the folks who have the actual knowledge and can give the guidance as to how to actually put into effect the trade secret, those scientists could be doing something else. For example, they could be helping to scale up the manufacturing process, say, in their own company, rather than educating a third party as to how to scale up. And finally, a major concern always when granting access to trade secret is how to put any effective limitation on use of the information. Sort of the cat can get out of the bag pretty quickly in that if you teach somebody a basic platform technology that may apply not just to a particular manufacturer of a drug or a vaccine, that can be used in other situations, that information can be used in other situations to then turn around and compete with the company who granted the access to the information in the first place. So where does that leave us? At the time that a patent issues on a drug, the reader of that patent, while he will know how to, or she know how to identify the particular active ingredient and a way to make that drug, they won't necessarily have a way to commercialize it in a way that could be safely administered to humans. And they may, in fact, need access to information that the patentee has as a trade secret. Turning now to another issue with respect to access to patented medications, relates to the linkage between regulatory agencies and patent litigation. And here I'm going to use as a model the U.S. legal process, and in particular here the Hatch-Waxman Act, to illustrate the point. So what is the Hatch-Waxman Act? It is an act which encourages access to generic drugs, and it is a bargain between generic drug companies and branded companies where each got something, probably not all that they would want. What does a generic drug company get? It gets to obtain FDA approval by an abbreviated process, and also the research that they conduct in order to get that FDA approval is not infringing a company's patents. And then there's also encouragement of a generic company in order to challenge patents related to drugs, and that is that a generic company that is successful in challenging a patent may be entitled to a 180-day exclusivity, meaning that they might be the only generic to sell during that 180-day period. What does the branded company get? Well, they got some patent term extensions, and so up to 5 years can get added onto a patent that the branded company wants to add that term to. Typically, you often see it added to the basic compound patents. And then importantly, they also get some FDA exclusivities. And then patent cases, challenges by a generic can be started prior to the approval of the ANDA. So it gets a head start on litigation. So what's the abbreviated path to FDA approval? A branded company would typically file a new drug application, and one part of that application is data demonstrating safety and efficacy of the drug. And then also, at the same time, they would be listing patents that could be reasonably asserted by somebody who may sell the same drug. What does an ANDA applicant do? Well, if they're making generally the same active ingredient, the same dosage, and the same dosage form, so that if the drug is being sold as a 10 milligram pill of compound X, and the ANDA applicant comes in and says, I want to sell a 10 milligram pill of drug X, they don't have to do safety and efficacy clinical trials. Instead, they can rely on the data, the safety and efficacy data that the branded company showed in their NDA. Instead of doing clinical trials on safety and efficacy, instead they have to do what's called bioequivalence studies, which is an interesting topic in itself, but I'll move on. So what are the FDA regulatory exclusive rights that an NDA holder gets that can block access to the medication? The NDA holder is entitled to a 5-year data exclusivity on what's called a new chemical entity. What that means is that no ANDA can be filed during that period. Slight wrinkle, which we don't need to belabor about that. It can be actually filed between year 4 and 5. But basically, there's a 5-year exclusivity where an ANDA cannot be filed. For a biologic, a BLA, that data exclusivity is even longer and goes out to 12 years, which can be a big block for things like vaccines. That's a long time. The branded company can also get marketing exclusivities from the FDA. For example, if there's a new clinical study that a branded company shows that their drug X can treat some new disease, and they do clinical studies to show that, they can get a 3-year marketing exclusivity. Now that doesn't block an ANDA from being filed, but it does block an ANDA from being approved by the FDA. One aspect that also blocks generic drugs from coming to market is the way that patent litigation plays out. When a ANDA applicant files an ANDA, they have to make a certification against those patents that the NDA owner listed. And in particular, one that is of significance certification is a paragraph 4 certification, where the ANDA applicant asserts that the listed patent is either invalid or not infringed. And in that situation, they have to notify the NDA holder that they made that certification, and that gives the opportunity of the NDA holder to bring a litigation against the ANDA applicant. And if the ANDA applicant does bring that litigation, then the FDA doesn't approve the ANDA for up to 30 months during the pendency of that litigation. And again, it's the paragraph 4 certification and successful maintenance of the paragraph 4 certification by an ANDA applicant that will give that first filed ANDA, the one who does it first, a 180-day exclusivity where that ANDA applicant would be the only one marketing the drug as compared to other ANDA applicants. Just want to turn to one issue that even at the end of the stay, even while patent litigation is pending, there is an opportunity for the generic to potentially launch at risk, because once that 30-month stay is over, the FDA can in fact approve the generic ANDA application, and that would allow the ANDA to launch at risk. Now, why is it at risk? Because there's still that patent out there, or patents that can be asserted and probably are being asserted against them. And that can lead to some severe damages, which make it not that enticing, perhaps, to roll the dice and launch at risk. Under the patent laws, a patentee is entitled to no less than a reasonable royalty for infringement of the patent. That may sound nice, but particularly, of course, the word reasonable is in there. But a patentee also could be entitled to lost profits, which with respect to a branded pharmaceutical could be enormous. So that the generic who launches at risk can be facing a huge damage award where they have to compensate for the lost profits caused by their infringement. And then also, patentees may be entitled to willful infringement, so that that massive amount of damages from lost profits could in fact be enhanced by the judge, maybe as much as treble. So where does that leave us when thinking in terms of access to patented medications? Do you need to move beyond merely looking at eliminating patents or maybe a patent pool and think in terms of access to things like trade secrets as well as how to deal with regulatory stays? Regulatory exclusivities.
Thank you, Daniel, for that look at the complexity of the legal as well as regulatory landscape that is operating in this area. Let me turn it over now to Lisa for our final set of comments.
Great. So thanks so much for the kind introduction and for inviting me here. Thanks to everyone for taking the time to talk about this today. So I want to just first note at the outset that my thinking about COVID is based on work I've done with a number of wonderful co-authors and collaborators, including work on vaccine innovation with Claire Shui, who's an outstanding JD PhD student at Stanford, work on the relationship between innovation and incentives and access with Daniel Hemmel of Chicago Law School, and a series of blog posts and forthcoming book chapter on COVID innovation issues with law professors Rachel Sachs, Jacob Shirkow, and Nicholson Price. So they all deserve a lot of credit for helping me think through the issues, the different legal issues here. So I wanted to start by stepping back a little from the COVID-19 context to think a bit about the economics of vaccine development, including why there's a even stronger case for government intervention in vaccine R&D than for other health technologies. So in general, there's good evidence that biomedical innovation is a driver of improvements in global health over time, and that innovation will be underproduced by the free market because of the public goods nature of knowledge, which is the basic justification for IP laws and other innovation policies. And in the vaccine context, this underinvestment problem is even worse. So one problem comes from the positive externalities of vaccination, meaning the large social benefits for people other than the vaccinated person, like reducing community spread of infection. And other problems come from the fact that a firm's profits for a vaccine will be lower than for a repeat use treatment, all else equal. So some of the pioneering theoretical and empirical work on this was done by economists Michael Kramer and Christopher Snyder using data from US markets. And Claire Shui and I expanded on these ideas to argue that there are also problems stemming from behavioral economics. So the standard solution to market failures is that the government should step in to correct them, and they have a broad toolkit of innovation policies to pull from, including IP laws as well as other policies. And in work with Daniel Hemmel, I've written about the differences between these innovation incentives and why no one policy is optimal in all circumstances. And I won't go into those details now, but I do want to highlight the way public policies that are designed to increase the use of medical technologies also provide an incentive to help develop those products in the first place. And indeed, the first study showing this was by Amy Finkelstein in the US vaccine context. And she looked at policies like childhood vaccine mandates and increases in Medicare vaccine coverage. And Rachel Sachs has written a lot about this in the insurance context. So this is one of many ways that policymakers can offer high-powered incentives to developers while making the resulting products free to patients. you might say, okay, great, the government has lots of tools to fix the vaccine innovation problem. At the start of the pandemic, we weren't off to a great start. Before COVID, public health scholars had long been warning that the world had made insufficient R&D investments in vaccine development and manufacture. And part of the problem here is that all of the market failures I described have corresponding political failures. So political institutions generally underinvest in long-term infrastructure because voters generally underestimate the risks, and any payoffs are usually longer than an electoral cycle. So the public sector hasn't invested enough in vaccine infrastructure itself, leaving most of the vaccine human capital and facilities in the private sector. And governments also haven't made vaccines sufficiently profitable for the private sector to encourage enough infrastructure there. Now, once the threat of COVID became apparent, we did end up getting vaccines authorized in record-breaking time. The development of most vaccines takes over a decade, but the first 2 vaccines were authorized in the US in less than a year. And part of that was getting lucky with the science. Part of it was effective FDA regulation, like setting clear standards to help guide clinical trials. Part was a substantial public investment in vaccine development. But vaccines are not vaccinations, and the rollout has been far more uneven. We're seeing the costs of not focusing enough on manufacturing capacity and distribution. So as anyone who's paid attention to the news over the past year knows, vaccine distribution in the US has had plenty of problems, including a disastrously slow initial rollout and really stark inequality by race and income. So that the exact nature of the problem has changed as domestic vaccine supply has increased. But 2 of the big problems here have been a lack of federal coordination and inadequate funding for this stage of vaccine distribution and administration. Because the public health governance structures in the US are largely decentralized at the state or local level. They're way underfunded due to the same kinds of political dysfunction that I described in the vaccine infrastructure context. Now, as bad as US vaccine distribution has been, the picture is even bleaker when you look at the rest of the world. So here's the latest map showing the global vaccine rollout so far. You can see stark disparities by income. So far, only 0.5% of doses have been administered in low-income countries. And this is a tragedy, and expanding global access to COVID vaccines is a moral imperative that hasn't gotten nearly enough public attention here in the US. And the official global COVID death toll is getting close to 5 million people. Estimates of global excess deaths have reached 15 million, which is just a mind-boggling number. And I'm not an expert at all in political mobilization, but I feel like even in a country that has never invested enough in foreign aid or done enough to address global health inequality, it seems like it should be possible to convince Americans that vaccinating the world is also in the US's interest in terms of bringing the pandemic to an end, reducing the likelihood of an even more dangerous new variant, and building international goodwill. And I've been glad to see this issue getting more traction from US politicians and news outlets recently. So what can be done about global vaccine access if we have the political will to do it? The legal option that's gotten, I think, the most attention for improving global vaccine distribution is a WTO waiver of COVID-related IP, which you've already heard about during Andrei's talk. I just saw that the WTO delegates are closer to reaching a compromise, but even if this does go through and then countries change their domestic laws in response, I think it's unclear whether it would have really any real-world effect, good or bad. So some of the supporters of a WTO waiver have pointed as a model to compulsory licenses on patented HIV/AIDS drugs during the 2000s, which were successful at increasing generic production and driving down prices. But there are important scientific and legal differences between those AIDS drugs and COVID vaccines, where for small molecule drugs, it is relatively straightforward to make a generic version that is an exact copy. And so patents are more of the key hurdle to production. For vaccines and other complex biologics, the generic version is known as a biosimilar. It's harder to show that a biosimilar is similar to enough to the original. And there are now some biosimilar versions of therapeutic drugs, but the FDA and its counterparts abroad haven't even issued guidelines on the regulatory steps that would be needed for biosimilar vaccine approval, either in general or in the COVID context. So the key barrier to expanding vaccine manufacturing isn't at all patents. It's the trade secrets and know-how and scarce physical supplies needed to get a new manufacturing plant up and running. Moderna already effectively waived its patent rights last year, but other manufacturers still aren't able to use Moderna's technology without active cooperation from Moderna. Now, it is possible that a TRIPS waiver would be able to help with some trade secrets, such as by making it easier for countries to try to force vaccine developers to disclose confidential information. But this kind of forced trade secret transfer would be unprecedented, would involve a lot of litigation, and it's not clear that confidential written disclosures provided to regulators would really be enough for an independent manufacturer. But I think this issue of how to expand manufacturing capacity, that's the key question policymakers should focus on. And to the extent this involves knowledge transfer, like this can happen now regardless of what goes on with the WTO negotiations. So I don't think it's right that vaccine manufacturers have readily licensed their IP to anyone who wants it. There's South Korean companies that have tried and failed to license the mRNA technology and have unsuccessfully asked the Biden administration for help brokering a deal. And there's a recent New York Times story that describes Biden officials urging Pfizer and Moderna to enter joint ventures, which led to Pfizer agreeing to sell more at a not-for-profit price rather than sharing, and no progress with Moderna, to the deep frustration of the Biden officials quoted there. And I think the administration has numerous sources of leverage that it could use to help broker these partnerships, including the Defense Production Act or government IP rights or the government's contractual rights with Moderna, or offering further financial incentives to encourage greater knowledge transfer. And I think that the U.S. should also increase funding for this problem, both in terms of supporting the development of manufacturing infrastructure in other countries, and just in terms of buying more vaccine doses for other countries, such as through COVAX. I mean, just in the US, COVID has been estimated to add $10 billion per day to the federal deficit. And I think a lot of the concerns about spending more money to address the pandemic have reflected a real failure to understand magnitudes and priorities here. So I don't know whether the best approach is to focus on all of these strategies or just one of them, but I think the decision should be guided by figuring out the fastest way to get shots in arms. So I'll just conclude by noting that I think our policy choices shouldn't just be focused on getting through this pandemic, but also in being better prepared for the next one. So here's a cover from Time in 2017, which is just one of many warnings before COVID about the very real threat of a lethal and economically devastating pandemic. But for the most part, all of the expert reports on this got about as much policy traction as the reports on climate change do now, which is not very much. And unfortunately, the fact that we're living through this now doesn't make a pandemic less likely to happen again soon. But maybe we can use this as an opportunity to improve our legal systems for biomedical innovation. So you hear a lot about drug prices being too high in the US, but too high doesn't mean anything in the abstract. I think the real concern is that the money that US taxpayers spend on new drugs often isn't aligned with social value. So it can be very profitable to launch a drug that doesn't offer a clinical benefit over existing treatments, or where there isn't adequate evidence of clinical benefits at all. But there isn't enough funding for things like vaccines or preventatives or public health measures in general. And the goal should be to get the marginal private value of R&D investment to equal the marginal global social value of that investment. And there are a lot of legal tools that could be used to shift biomedical funding in the right directions. And I think it's also important for policymakers to recognize that these issues of innovation funding are distinct from issues of access to those innovations. and that describing innovation policy as creating a trade-off between incentives and access is a false framing. A key conceptual mistake that keeps getting made in access to medicines discussions is not distinguishing between out-of-pocket costs for patients and the entirely separate question of financial rewards for developers. The vaccines can be free to patients even if developers receive enormous financial rewards, and there are plenty of policies that increase both incentives and access. So the main strategy of many access to medicines advocates has been to focus on limiting IP rights and encouraging competition from generic manufacturers, which is an effective strategy for some kinds of medicines. But there are plenty of off-patent drugs that have faced shortages, high prices, and other access barriers. And the connection between patents and access is more complicated than simplistic economic models suggest. So I think it's important to broaden the understanding of access to medicines among academics and advocates and politicians to include reforms beyond this current playbook. So I will stop there.
So thank you, Lisa, also for giving us a lot to think about, both in terms of what to do in the face of the ongoing pandemic we have now and what to do going forward. And I really do think that is one of the things that complicates the discussion here, is that we have a set of vaccines that have been developed. There are perhaps some lessons we could learn from the process that got us, from there to here. And we're now trying to figure out how do we actually get these made and distributed. And then there's a certainly related but separate set of questions of, okay, how do we put the right incentives in place, the right funding, the right infrastructure, whatever that may be, to mount an effective response to some future pandemic. So what I want to turn to now is a chance to really allow for a discussion between our panelists. I have a few questions and ideas to get us started, but I do welcome the panelists to raise other points or put additional topics of discussion out there to make this as productive as we can while we're all thinking about this together. To start with a sort of concrete question, since in various ways each of you has been involved in or studied the process of getting the vaccines developed and getting up to the point of our initial manufacture and distribution, is there anything reflecting back that you might have done differently in structuring the process? And I put that out there broadly, since this could be things having to do with Operation Warp Speed, or it could be things having to do with aspects of the funding or compensation mechanisms, or things that weren't even talked about, but maybe should have been. Your thoughts?
Well, I can start, BJ, if you'd like. Yeah, there are lots of things that I think governments around the world could have done differently. Somehow the whole world was caught by surprise, even though in the scientific community, everybody knew and was worried about pandemic flu and the like for a long period of time. Yet governments around the world did precious little to prepare their own countries and then at the global level. And what we are seeing is, short of this miraculous warp speed development of the vaccines, but the world coordination surrounding this was left basically to scramble in the wake of the pandemic. What I think is critically important, a lesson to learn from this and looking ahead to the next worldwide health crisis, whether it's a pandemic or something short of that, either way, I think governments of the world have a responsibility to get together and have a plan. And it's not rocket science here. I mean, it's something that can definitely be worked out. For example, we have the World Bank on the financial side, where countries have gotten together on fiscal issues, and there is a way to coordinate between the rich countries and the developing world on matters of economics. Why don't we have a World Bank type of an institution for pandemic and medicine distribution in case of worldwide crisis? Rules can be put in place ahead of time as to who contributes product, who contributes money, and then how it gets distributed and the like, so that these decisions can be made, at least the framework of decisions can be made ahead of time. That's just one of many, many possible thoughts. But my main point is all of this needs to be thought about ahead of time. And here is the main concern that I have, BJ. All this worldwide discussion about IP rights and waiving IP rights has frozen the world's thinking about the issues that actually can make a difference. The world governments are the only thing they're discussing that's in a meaningfully advanced stage is this waiver of IP rights, which in my firm belief, it will not get a single shot into people's arms, additional shot into people's arms that should be gotten. And in fact, it will make it less likely that distribution will take place in a broad-based basis and additional innovations will be created. But the biggest tragedy is that it's prohibiting effectively the discussions on things that actually matters. Collaboration between countries with respect to export controls, for example. Wealthy countries are hoarding vaccines. It's not a secret. And countries have export control laws in place, the United States included, and others. How about having a worldwide discussion or at least in the G7, G20 somewhere about how that should be addressed? How about having a worldwide discussion at a high and advanced level about transportation and other logistics and how poor countries can finance the purchase or acquisition of vaccines? All this focus on the WTO waiver is enabling governments to hide behind those discussions and not focus on the things, in my view, that will make a difference. And finally, I'll leave you with this: capacity building. The West has been talking about working with the developing world for building capacities, whether it's for vaccine manufacturing or other advanced medicine manufacturing, for decades. Precious little, next to none, has been done on a worldwide, meaningful basis. And we were caught here once again exposed. If we really want the developing world to be able to manufacture vaccines on their own, as they should, we need to get going now. It takes a very long time with training and standing up factories and building production lines so we can help them along the way for X period of time so that when the next pandemic hits, they'll be ready to go. Those are the main issues that I wish we would have done beforehand, but now at least lessons learned we can do for the future.
I mostly agree with all of that, and including I agree that I have been sorry to see how much airtime the discussion of IP waiver has gotten. I mean, I think I disagree that it's not clear to me that it would be actively harmful, but I think that it isn't likely to have a real world impact for the reasons I explained, and that it has been sucking up a lot of the oxygen on the and preventing discussion of the other things that governments should be doing now, which include, there's both now and for the next pandemic, spending more money at the places that are the real bottlenecks so that you can get more vaccines that are developed and then into patients' arms. So as a kind of initial step in this direction, the Biden administration recently put forth this American Pandemic Preparedness Plan that lays out some kind of general pandemic preparedness goals. And I think one can quibble on the exact allocation of funding and things, but that kind of massive public investment in basic research related to vaccines and relevant and other medical technologies, and also a commitment to not just the basic research, but the manufacturing capacity issues, the public health systems at the state and local level. That's the kind of investment we should have made before, and perhaps now we'll have the political will to get it through.
And I would agree, and I come at it from a slightly different angle as somebody who spends the vast majority of his time helping companies enforce patents. And I think if you look at how the industry has responded to any enforcement in this area, it might shed some light as to whether a waiver of IP is a sideshow, because you just haven't seen it. And in the instance that I can recall where there was a patent case that might have overlapped with some assays, the case was quickly dropped. But does that mean that it won't happen in the future? And particularly when you think in terms of that damages could be accruing and whether something needs to be done. But it does seem as if the IP waiver issue isn't what's the impediment to expanding access.
BJ, if I can add something very quickly, which is, even though it seems like we were caught by surprise when COVID came around at the end of 2019, early 2020, even then we had a year before the vaccines came around. It wasn't like the vaccines dropped out of the sky, like, ooh, shock, we have a vaccine. Like the world was working towards a vaccine. That was the whole point of Operation Warp Speed. Why, since you're asking what would we have done differently, how about use that year and, work among the leading countries of the world, whether it would have been at the WTO or in G7 or some multilateral fashion to say, when they do drop, whether it's in 9 months from now or 20 or 18 months from now, how should we distribute these around the world? Nothing. I mean, maybe it was at some low level, but nothing was done. And then, we're caught in a reactive mode, essentially.
So that is one thing that I wanted to actually call attention to. So I'm glad that together you did, that there's agreement here in terms of this question, is the proposed IP waiver going to fix the problems? And there are a lot of reasons to believe that it's not going to do so. At the same time, there's still a desire there to create the capacity in the developing world to produce more of this drug. And there do still seem to be obstacles in the way to convincing the companies that have the know-how and the other sorts of technical knowledge to produce these vaccines. There's a reluctance there still, even in the story that Lisa referenced with the Biden administration putting pressure on some of these companies and them still dragging their feet. Now, part of the answer to why there are, or part of the obstacle to why these things are not going to take off overnight, for sure, is supply chain problems. Even if they had all the knowledge and know-how, they still need the necessary reagents and everything else. But in terms of just that knowledge transfer, do you have any insights into what the remaining obstacles there are? Why is there a mixed response? Because as Andrei pointed out, there have been many collaboration agreements across many different kinds of entities. So what is the holdup in these that we see where there is some sort of obstacle? If, and again, you can only speak from what you know, and you were not in the room when these deals were not taking place.
I don't know. I don't know what the holdup is because I am not there, and so it's relying on reporting like the New York Times story I referenced, or discussions about the South Korean manufacturers who are trying to get access to the mRNA technology and not able to reach any kind of deal with Pfizer and Moderna. And maybe those South Korean companies are being unreasonable in the way they're asking for it, or like that there's some problem there. But I feel like the people who are in those conversations should be trying to do what they can to make that collaboration actually happen. And that, so like, that should be the question that the Biden administration officials are focused on. And they have sources of leverage that, at least from the public reporting, it's not clear that they are using to try to force more collaboration than is currently going on.
Yeah, am I unmuted? Yes. I'm not familiar with the actual reasons either. The only point that I would add, perhaps, particularly when you're thinking in terms of maybe some of the smaller companies like BioNTech or Moderna, that it's the trade secrets that they've developed around the mRNA technology, they probably view as extraordinarily valuable. And I'm sure there's a reluctance on their part to give away a platform technology. And how would one craft a way to give away a platform technology for just one use at this particular time is probably a challenge, as opposed to giving away their entire store, so to speak.
They can be compensated for that. Like, I mean, that's one of the things the Biden administration can do, is like pay for that. And I mean, I understand from their own private perspective the reluctance to do that. But like, if there are companies like the firms in South Korea that like have ability to be manufacturing more than we are to meet the extraordinary global demand, someone should be willing to pay for that.
You know, in some ways, it seems like a sort of mismatch with the kind of protection that it has. There's this idea that if there's patent protection, then licensing it, sharing it, putting it out there doesn't put you at great risk. You can also license a trade secret. There are more complications because there is that risk that the secrecy could be intentionally or inadvertently destroyed, and you might lose that right. But in theory, it's supposed to be the kind of IP right that one could license, which points to a sort of problem in practice for that form of protection.
But it does get licensed, and it has during the pandemic at unprecedented levels, both the patents and the know-how. That's the whole point of these collaborations, including the cross-country collaborations. So specifically, again, take the AstraZeneca and the Serum Institute of India, where the Serum Institute is manufacturing the whole thing. And there's lots of other collaborations where various companies around the world are manufacturing components or sub-assemblies or and the like. All that is based on a transfer of knowledge. The know-how that you mentioned, BJ, together with the various IP rights, but that can only happen if the owner of that know-how is comfortable that the rule of law will be respected, and that once that gets transferred, it will be protected, and they won't just waive those protections or, voluntarily get rid, suspend the protections and, spill the beans, as they might say. The rule of law, belief in the rule of law is critically important here to enable such transfers.
So I'd like to bring in some of the questions now that we're getting from the audience, because there are some very important issues being raised. And one of these, which perhaps is a question of disentangling as well as a question of policy and values, is a question about, how do we justify the extent of IP protection that is given to a vaccine such as this when it also receives these additional incentives? And this question lists government funding of clinical research, advanced purchase agreements, FDA emergency use authorizations, and so on. And the concern, as the question articulates it, is that this may overburden follow-on innovation or vaccine access, or perhaps it's imposing sort of costs that don't need to be if so much compensation has already been given. Any thoughts on that subject?
Sure. Yeah, I think it's an important question to think about. And the vaccines that we have now, they did benefit from substantial public funding. They also reflect substantial private sector contributions. And like you'll sometimes see statements in the press, the Moderna vaccine was entirely government funded, which isn't really right. Before COVID, Moderna had been doing mRNA research for a decade. Grants were a tiny portion of their R&D expenses. They had an accumulated deficit of over $2 billion. And even in 2020, their R&D expenses far exceeded all sources of revenue, such that they had a net loss of $750 million. So there's private sector R&D resources that are being spent here, and that I think should be rewarded because of the problems with trying to encourage greater investment. That we have underinvestment in vaccine R&D from both the private and the public sector. But I think the role of government funding here is important, and that the ultimate goal from a public interest perspective should be to try to make it so that the vaccine producers are investing up to the point where the marginal private value that they are getting is equal to the global social value, the marginal social value, which for vaccines is greater because of the positive externalities and things like that. And so that's why there is why it makes sense for, even in a world with IP, to also have additional government funding for things like vaccines. But I think the IP has another angle here, in that it is one of the pieces of leverage that the government can use, where the government has ownership of some of the relevant IP, to help encourage companies to enter into these deals to transfer their technology for appropriate compensation, but to make sure that those are happening even if they aren't the company's first choice, compared to keeping everything proprietary.
to follow on Lisa, unless Vijay, you wanted to say something else. A couple of points in response to that important question. Number one, as Lisa indicates, all of these are a public-private collaboration. It would not have been able to happen, especially at the speed that we have done it, especially the amount of innovation that has had to take place for decades before the actual particular COVID vaccine. None of it could have happened without the private sector. And the private sector simply does not invest the type of dollars needed here at the huge amounts of risk that these companies take without the protections of IP. So if we want the public sector, the private sector, the industry to invest and innovate, then we need IP protection. Second point, it's one thing to say that that for moral reasons or for public policy reasons, we're not going to give IP protection for certain things like vaccines and so on. It's a different, and I don't agree with that, but it's a possible position for one to have. It's an entirely different position to say that we're going to change the rules of the game after the fact, after the investments and after the innovation was made, under the promise that long-standing promise that those investments and that innovation would be protected. Now, after the fact, after the cat's out of the bag, to change the rule of the game is an entirely different proposition, and it's a dramatic weakening in respect for the rule of law and the belief in the rule of law that's critically important in any free market system. Third point is this. I've heard this argument being made a lot about government has invested, US taxpayers have invested money here in some of these vaccines, and therefore we should agree with the India and South Africa proposal to suspend IP rights. That argument doesn't compute for me. If the US taxpayer actually paid for a portion, or some argue the significant portion of these vaccines, why should the US taxpayer voluntarily give it away to the world and potentially to our enemies in some places around the world? If it is a US taxpayer question, shouldn't the US government protect the US taxpayer's investment? But anyway, that's a much smaller point as compared to my first two.
Can I just ask on that last point, like, don't you think it's in the U.S. taxpayers' interest to expand global vaccine access, even to countries we might not agree with on all issues?
Well, sure, it is in the U.S. taxpayers' interest. The ultimate goal, I personally agree, not everybody agrees, obviously, but I personally very much agree that it is really important to expand access and have a more equitable distribution. But the first, fundamentally, as we discussed already, I don't think that waiving IP gets us there. But if it is based on a question of the US taxpayer invested, therefore we should waive, that's what I don't understand. It's okay to say you want broader access and you happen to believe in that part of the argument that waiving IP rights will give better access around the world. I get that. You can make that argument. I don't agree with it, but that's okay. I don't understand the other argument, which is it should be the taxpayer invested and therefore it should be waived. You see what I'm saying? I don't see the connection between those 2 points.
I'd actually like to raise another issue that's related to this. And this is something that, showing my own lack of knowledge of the specifics may be just something that people have repeated, like this idea that Moderna's research was all publicly funded. But part of the way that the press has sometimes described the way that the deals were structured when this research was kicked off is that the government essentially de-risked a lot of this research by pre-committing in various ways that seem, according to the reporting, to be unusual and unprecedented. And I was wondering if you could clarify that, and to the extent that you are familiar with those sorts of arrangements. And is that just sort of an ad hoc thing that we would expect to see for certain kinds of medications, perhaps vaccines, or is that approach to funding R&D something that could be incorporated in a more regularized way in patent policy or innovation policy or public health policy?
I personally did not understand the question, BJ, so I'm going to defer to Lisa and Dan.
Sure, I could take it. I mean, so yes, with the substantial public funding that reduced the risk for the companies of developing these drugs, as there was a unprecedented amount of public funding for these vaccines, and I think that's one of the arguments that's being made that's in favor of more government intervention in pushing them to now be expanded more broadly and to facilitate greater knowledge transfer. I mean, going forward, I suspect that if we're in a similar situation where there is a globally devastating pandemic, that governments would again step in and cover costs and cover clinical trials and purchase vaccines, and that companies would expect that. And even if the governments, some scholars have argued that the government has the Moderna recipe and should be releasing that now so that people can use it. Moderna is going to come out well ahead in any case, even if that happens now. I mean, I think there's a kind of broader question about the role of the public sector in drug development more generally. And as I mentioned during my remarks, the public sector has not invested a lot in later stages of drug development, it's typically not in the business of running clinical trials themselves. And there's nothing inherently right about that particular private sector, public sector division. I mean, in some ways, it seems kind of odd that a process that's focused on complying with a federal regulatory agency to develop the evidence that they need, that we've entirely pushed that piece to the private sector, and that the public sector typically is involved more in the early stages of drug development. So, I mean, I have written in some of my articles that I think there is a argument for greater public sector funding for clinical trials, including for things that don't have sufficient profit for the private sector to be developing them. And that's one of the ways that when we're thinking about reforming biomedical innovation institutions going forward, that thinking about the optimal private-public sector split is one of the important issues to think about.
Yeah, I would echo that, because it sounds to me that it's a failure at the time to not have negotiated at the time of the funding what's going to happen down the road as far as access or intellectual property rights. So perhaps going forward, one could think ahead of time as to how you want to carve up these rights so that there's a blueprint to follow, if we face this situation again.
So I see we have a number of questions in the Q&A that I would like to put before you. Some of them get into really some of the nuts and bolts of various proposals. Before I do, though, I don't want to cut off the discussion. Were there any other points that you had wanted to get into? All right. So first of these, getting into a nuts and bolts question. We have a questioner that works for a company that sells patented purification articles of manufacture used to make biologics and or drugs. There are several companies like this that sell specialized, often patented manufacturing equipment to drug companies. We might think also of other reagents and inputs that a company sells that might be covered by a patent. And these are things that are required for manufacturing these drugs. So in the context of something like the IP waiver, how would these sort of subsidiary IP protected sorts of devices and inputs be treated?
It's an excellent question. The waiver proposal is vague on that. And I'll tell you, I'll read from it what it covers. But irrespective of what the proposal is, the real question is what's going to be the agreed upon text, if in fact there will be some agreed upon text. So we don't really know right now, but the proposal is that it would focus on health products and technologies as the prevention, treatment, or containment of COVID-19, for the prevention, treatment, or containment of COVID-19. So if your bottom line is, if the questioner's product relates to COVID-19 in some fashion, it is likely to be within the scope of what the request was from India and South Africa. But again, Ambassador USTR, U.S. Trade Representative Ambassador Tai, when she stated the U.S.'s position supporting in principle some form of a waiver, she focused specifically on vaccines, and the U.S. hasn't made a much more specific statement since then. We don't know exactly what it's going to be. If I had to guess, it will be a narrower set of technologies than what the current proposal is from India and South Africa. Will it be more than just vaccines? If I had to guess, probably, but it's somewhere in that range.
I think it's also worth just explaining exactly what the waiver would do. I know that many people in the audience are not experts on WTO or the relevant international treaties here, because like the question asks, would companies have to surrender their IP rights? But the waiver itself would not get rid of any IP rights. So what the waiver would do, so the WTO, World Trade Organization, they administer treaties, including the TRIPS agreement, the agreement on trade-related aspects of intellectual property rights. And TRIPS requires countries, basically all but the least developed countries, to offer certain IP protections like patents to inventors from any other WTO members. And so waiving IP protections in TRIPS for COVID-related medical products, that would mean that if a certain country chooses to change its domestic IP laws, then another country couldn't initiate a formal WTO dispute against it. So for this to do anything, you need the WTO to have the TRIPS waiver, and then a individual country to implement that domestically and say, and there's lots of ways they could do that. They could say, okay, we're going to have compulsory licensing of these rules. I mean, TRIPS does allow for some compulsory licensing under certain circumstances, but they would no longer have to comply with the TRIPS procedures for that, or other limitations on IP rights that wouldn't be compliant with TRIPS. And I also think it's worth noting that it's not clear to me why, whether the threat of a country initiating a WTO dispute is such an important thing here, because the WTO dispute resolution process is currently in crisis because the U.S. has been blocking nominations. And WTO sanctions are far from the only constraint on domestic IP laws. So that's another reason that it's not clear to me why the TRIPS waiver has gotten as much attention as it has, compared to just countries doing things domestically.
I totally agree with what Lisa just said. It's this is what's frankly so frustrating about this whole international debate, because even if there is agreement, and again, you need consensus, all the countries need to agree to the final text. Even if there is agreement, then countries need to decide whether they're going to implement. So then you have to go to the national level. In the United States, you're going to need an act of Congress, both chambers passing the new bill, signed by the president like any other bill, and you can imagine the debates here and try to get majorities in both chambers of Congress towards that. By the way, in the United States, there's an even further complication. Trade secrets are very often protected by various state laws across the 50 states. And imagine what that would take, and the potential litigation surrounding not just the federal implementation, but also at the state level. Lisa's also right that TRIPS already includes compulsory licensing provisions. So countries could choose right now, as we speak, to issue compulsory licenses around these technologies, including vaccines. Nobody has in any meaningful way. And one has to wonder why that is. And finally, all IP rights are already waived to the least developed nations. So there's a long list, not long, but there's a list of least developed countries, LDCs, that the UN maintains. TRIPS doesn't apply to them until 2033. And probably that's going to get extended as it always does. So countries around the world that are on that list already don't have to comply with TRIPS. And this includes countries that have vaccine manufacturing capability. Take, for example, Bangladesh. Bangladesh has a meaningful vaccine manufacturing capability. TRIPS doesn't apply. The waiver is meaningless to them because they already have it. Why aren't they making the vaccine or anything else for that matter surrounding these technologies? It just illustrates how unlikely it is that even if they get what they're fully get what they're asking for through this WTO waiver, really nothing much is very likely to change or anytime soon.
So another question that's just come in gets back to some of the earlier comments about how do we prepare for the next sort of global health crisis, one that looks like this, maybe one that looks very different than this, because as the question asks, given mRNA is a new technology, in order for other countries to manufacture using the new technology, how would the world build the intellectual infrastructure worldwide in preparation for manufacturing, or even know what new technology will be important? And I would maybe take that one level more general. If the idea is that we should invest in the infrastructure that is necessary for some next generation of vaccines or treatments, how do we know that those things won't be so novel or so unprecedented that anything we might try to build or fund in anticipation is going to be aimed at the wrong target?
I mean, we don't know that everything, in fact, we know that if we're investing in a bunch of different R&D avenues, not all of them are going to pan out. Then that's how R&D works. That's why it is risky, and that's kind of the basic justification for public funding for R&D, particularly on very risky basic technologies that have wide application, but the payoffs are extremely speculative and long-term, such that there's less investment from the private sector because it's not clear that you're going to have a payoff within the length of a patent term. So we don't know that. We do know that the investments that we made in science and vaccine manufacturing, they paid off in the sense that we at least had the stock of knowledge to be able to get to the point where we could have vaccines authorized within a year. So even though no specific project is it clear that that's going to prove to be a winner, by looking historically, the social returns on R&D investment are enormous. I think we can expect that they will continue to be large, that this is generally a good use of taxpayer dollars. Now, in spending those taxpayer dollars, it's worth thinking about where are the areas where the private sector is least likely to invest, or where there's particular hurdles to private sector manufacturing and vaccines in general, vaccine manufacturing, drug manufacturing processes in general, preventatives in general. Like there's certain things where there's the private sector is even less likely to invest than for a normal small molecule therapeutic. And so those decisions on how to spend public R&D funding should be guided by those concerns. But we don't know which one will ultimately be the one that we need.
And that's just the way innovation is, right? By definition, innovation is new and not predicted beforehand, really, because otherwise somebody else would have invented it beforehand. But that doesn't mean we shouldn't invest in capacity building around the world for at least two main reasons. Of course, there's lots of others, but two main reasons. One, you're enabling those other countries to become innovators themselves. Maybe they are going to be the ones who come up with the next great breakthrough. Take BioNTech, for example. German company, small company, startup, took place over there. If we build capacity, it's currently in the current developing world. In the next pandemic, maybe they're going to come up with the new innovation. But second, even if they don't, and still you have innovation that's developed first in the West, at least they have the capacity from the get-go to be licensed through the know-how such that they can stand up a production line quickly under a transfer of know-how agreement with the manufacturer. So there's huge benefit in creating capacity around it, really as broadly distributed around the world as possible. Not to mention, of course, just the inherent benefits of having advanced technologies, having industries within one's country, better paying jobs, higher standard of living, proliferation of ancillary businesses surrounding those new technologies, so many other things.
I would agree with that. And obviously, no one knows what the future holds as far as any technology that might replace mRNA technology. And it's obviously very risky to think as far as an investment in something like that. But we do know that mRNA technology does work. So as far as the next pandemic, it seems like there'd be a good opportunity that technology could be useful. So figuring out how to disseminate that to as many players makes sense.
Another question that's come in is one that is sort of emergent from some of the technicalities in the difference between patents and trade secrets. Patents, of course, have a limited term. They go for no longer than 20 years, while trade secrets are potentially unlimited in term. Patents have disclosures that are required. So it is known to the public, eventually there will be no further exclusivity, while trade secrets, they're secret, they're not disclosed. And so long as they maintain that secrecy and so long as they maintain their value, they will continue to be the exclusive purview of whichever company developed them. The question is, with public funding of pharma research, while patents have a term, trade secrets do not, as a public policy matter, should trade secrets that are the result of publicly funded research in whole or in part also be without any term in the same way? And I take it as the question in some way is if the company that's publicly funded gets a trade secret rather than a patent, are we missing some of that quid pro quo that would justify the public funding?
Yes, I think it's a important question, and I've written a lot about having patents on publicly funded research and the situations in which that makes sense and doesn't. I think the arguments do get harder when you're talking about trade secrets that's like, to me in the university context, the idea that like a publicly funded university researcher is having, is like maintaining some of that as a trade secret that they're licensing to companies, which I know has happened in the university context, but it seems counter to the goals of disclosure of this information that I think ought to be part of the agreement for the public funding in the first place. Funding to a private company, I mean, it's I think more complicated there, and it depends some on what exactly the funding is covering. And like, I don't think it's the case that just because a company has received any public funding that means the company can't have trade secrets. But I think that the government, the grant-making agencies that are involved in these contracts should make sure that they are funding things that are contributing social value, including to the store of knowledge for other innovators to build on. And that can get tricky when then some of that publicly funded information is being protected as a secret.
I think it seems problematic to me to look at this in retrospect, in that a company who had received money and then no one either thought of or wanted to discuss intellectual property, it puts probably both parties in a bad position, but it could really end up stripping some value, tremendous value, that arguably is separate from the going forward. Research collaboration deals often include ownership of intellectual property rights, trade secrets. It's something that the industry is very comfortable negotiating over, and it's done all the time.
And I also want to acknowledge some very important questions that have come through in the chat as to ethical considerations that should apply. And I believe each of you has addressed facets of that question, as well as issues that are extremely important in this conversation. One thing that is clear is that even when we're talking about the innovation and the sort of just material aspects, the science, the technology of these vaccines, more than patent is in play, without a doubt. More regimes even than intellectual property are in play as we think about how this intersects with various health regulations, how this intersects with the things that have led to even the supply chain issues that are standing in the way of progress on some of these issues. And of course we have another layer of questions that we would want to invite ethicists and philosophers and medical ethicists specifically to speak to, as to the inequity of how many of these treatments have been distributed, or the questions of whether or in what contexts it would be appropriate for a vaccine to be made compulsory. One final question that I would like to put out there from the audience, and I believe this goes to a point that Andrei made earlier. Wouldn't any patent reform necessarily require a reform after investments have been made? Does this foreclose any patent law reform?
Look, it's a good question. It depends how you write the law. You can always make reforms that are forward-looking, that apply to only patents that issue, for example, or are applied for after the enactment of the law. If you think about the last major patent law reform, which was the America Invents Act, signed into law by President Obama in September 2012, I believe. September 2011. We just had the 10th year anniversary. For a variety of the provisions, they were applicable only to patents issued after a certain date. Same with other changes in the law regarding GATT in the 1990s and the like. So that's just doable by the way you write the law. But fundamentally, one really has to think about anytime you're thinking about making changes, you have to think about what sort of vested rights you are affecting. There are all sorts of patent laws that are positive in nature, granting additional protections, granting the public additional tools by which to challenge a patent or whatever. But when you are simply talking about, as in this particular proposal, the complete removal, just the complete deletion of the entire bundle of rights that the government gave you, years after the fact, huge investments of dollars later, on a large public scale, one has to think about the broad-based implications, and I think you can decide that it just cannot be done from a public policy point of view because too much is at stake, too much has been invested, and then you can start thinking about the philosophy and the public policy considerations, economic considerations about forward-looking changes that affect industry into the future.
So I think it is, I agree with Andrei that like whether a given patent law change is retrospective or not, like that it depends on how you implement it. And I'll just make a shout out for a article in the Stanford Law Review by Jonathan Mazur and Adam Mortara called Patents, Property, and Prospectivity that deals with that exact question and the way, like when a judge is changing the rules on patents, they're generally retroactive and arguing that even in the judicial context, they don't need to be, thinking about when you can make changes prospective only. It's a great article, and Jonathan Mazur is also my co-author on our free patent law casebook that you can get at patentcasebook.org for free download. So like I think that's true that like when you're making any patent reform, you should think about whether it should apply only prospectively or not. And I agree that it's important when reforming patent law to think about what are the incentives for inventors going forwards, like that if you're radically changing the rights, then that's can not provide enough certainty for inventors for the patent system to be providing a incentive for them. Then I'm less concerned about like for an individual, like every individual patent holder, whether their rights are maintain this consistently over time than about the overall, like from a public policy perspective, the question is on average, what will inventors expect from the patent system going forward? And is that enough that they'll be incentivized to invest?
I just want to pick up quickly on the last point that Lisa made, which is excellent. Let's apply that in the immediate context of the proposed waiver and the immediate consequences of the proposed waiver. So the proposed waiver, again, depends on how it gets implemented and all of that. But the proposed waiver says that rights will be waived for COVID-19 technologies. There are people right now investing right now, researching, inventing right now to create new cures, new treatments still for COVID, for the COVID disease. So there are folks in labs right now trying to come up with a pill that if you do contract COVID despite the vaccination, that it can treat you or remove the worst symptoms. And that takes a lot of investment and of time and resources. Now, if you pass that law now, and you and these investors and inventors right now know that it's a done deal. I don't have to guess. I now know I will not have patent protection on the very thing, or trade secret protection, on the very thing I'm investing potentially billions of dollars, because it costs over $2 billion on average to bring a drug to market. Am I going to do that? Knowing this, it's a very interesting question, and it's not a hypothetical about how innovation might be affected in the future. The question is now on COVID-19 related technologies.
I think we completely agree on that, and that it's important to preserve incentives for those investments. I don't think that means that one can't do anything related to the patent rights, and that there are ways to, for example, compensate patentees for their investments, compensate Moderna for the loss of trade secrets by forcing them to collaborate with the South Korean manufacturers, and that the thinking about incentives is important, but there are a lot of different tools that the government can use to provide those incentives, and the patent system isn't the only one.
Sure, in retrospect, you could try to do that and compensate for the forced taking and whatnot, but think about, the companies, the startups on the margins, not the Pfizers or the Johnson & Johnsons and Mercks and whatever that have a huge pool of their own resources and they have other incentives. But the folks who need to raise money now, will they be able to raise the money now to start a new product line, a new company surrounding a new technology, given all the risks that come along with that, if they know right now for a fact that they won't have patent and trade secret protection, and that the best they can hope for is to get some sort of unspecified compensation later on if they have to sue or ask the government for some compensation or some sort. I don't know that there are any studies that tell us conclusively how industry would be affected right now, and that, that in fact, we're not going to put downward pressure on the innovation of new COVID-19 related treatments right now if such a waiver actually goes into place.
Though it's a little weird to put the burden on. I think we ultimately agree on the need to preserve these incentives, and that there are multiple ways you can do that. The effect of the patent incentive on innovation in particular, there actually aren't studies showing that patents increase research investments. If you're, it depends on who has the burden of showing the relevant thing with the study. So I think it is important that we design a innovation ecosystem where innovators are going to be rewarded for their investments, and that those rewards should be tailored to the social value that those investments are provided, but that there are a lot of tools we can use to do that.
Well, we've had the U.S. patent system since the founding of the country. Everything that we have done since the founding of this country to now is under the auspices of the patent system, with its changes over time, but nevertheless with patents all along. The current innovations that we're talking about, the COVID-19 innovations that have already taken place, including the miraculous less than 1 year production of multiple vaccines, all done under the auspices of the patent system. So I do think the burden is on those who want to change the status quo. The burden is to show that if you want to affect the change to what the current system is, A, is the new system that's being proposed, is it going to behave at least as well? And B, is it going to not do more harm than good? I would actually add a C, or a preliminary question, which is, where's the evidence that it's needed? But anyway, in terms of burden, I think it's incumbent upon those who want a change from the status quo.
And, as we get into this set of questions, I think it speaks to, the importance of the set of issues that we are faced with here. The Kastenmeier Symposium, named in honor of Robert Kastenmeier and his many years of service in the House of Representatives, is meant to bring issues of national or global importance back to this audience in Wisconsin, and due to the particular setting we're in here now, an audience even beyond Wisconsin. The issues and questions as applied in this case, as well as more fundamental questions of how we should structure innovation policy, the role of patents, the role of other incentives, the incidental effects of regimes that we might not have even realized bore on this, like health insurance and what that means for innovation. All of these are extremely important, at times contentious, and vital for us to keep talking about and keep working through as we prepare to face health challenges of the future. Unfortunately, we are winding down in our time for today. It has been a privilege to invite Dan and to invite my old colleagues, Andrei and Lisa, even if only virtually, here to Wisconsin. And I have just one final housekeeping note for those who have been patiently waiting for CLE credit. The passcode for today is SHARK. I will not reference a particular children's song, even though we've been talking about South Korea. A Google form link has been entered in the chat. So if you are hoping to receive credit, the password is SHARK. And please go there and enter the password by 11:59 p.m. Tonight on Central Time. And with that, I turn it back to Dean Takagi.
Well, thanks so much, BJ. I have a few thank yous. One to Kim Rather of our outstanding external affairs team at the University of Wisconsin Law School for her excellent work in putting this together and handling logistics. I want to thank the Kastenmeier Committee for organizing this, and a representative of that committee, our Associate Dean for Research and Faculty Development, Anuj Desai, who is here with us, for putting this together. Thanks for doing such a great job. BJ, thanks to you for so skillfully moderating this expert panel. And finally, a thank you to all of our panelists. This is not exactly the simplest subject to understand, and yet you all have done, each of you, an excellent job of making it comprehensible to those of us, and I suspect it's most of us who are participating in this symposium, who come into this without expertise in patent law. So I really do appreciate the engaging and exceptionally clear presentations you all gave us. At this point in the presentation, if we were in person in the normal course of events, this would be the point at which I present to each of you a replica of the symbol of the University of Wisconsin Law School, our gargoyle, which I'll try to, well, see how that works. Okay, you can sort of see it there. The gargoyle, actually the gargoyles, were part of the previous building that the law school occupied at the heart of campus at the University of Wisconsin-Madison until 1963, when the building was torn down to make way for our new and current building. As legend has it, when the old building was demolished, the then Dean George Young found one of the gargoyles amidst the rubble and preserved it in a pretty much undamaged form. So it became a part of our law school's lore and history and the symbol of the law school in succeeding years. The other gargoyle was thought to be lost, but actually turned up just about 3 years ago and now sits in my office. It had been recovered apparently by a former student of the law school and made its way around the state of Wisconsin and ultimately to Virginia before being returned. The gargoyle is a symbol of the strength and indomitability of our great law school. It is also now, with the return of the second gargoyle, a symbol of coming back to Madison to visit. And so we hope you all will do that, even though you didn't really have an opportunity to visit us in person in Madison, which is absolutely lovely this time of year. We hope you will. We hope you will have the opportunity to come see us and to participate in further presentations and events at the University of Wisconsin Law School. So I will symbolically present the gargoyle to you all. The replicas will be in the mail on their way to you as a token of appreciation for your really fabulous participation in this year's Kastenmeier Symposium. Thank you to our panelists. We are all symbolically applauding you, and I want to thank all of our attendees today for joining us. We hope that we'll have many more opportunities to welcome you virtually and hopefully before too long in person to our beautiful campus. Thanks, everyone. Hope to see you soon.
Thank you.
Bye. Thank you all.
Thank you.